Hi, and welcome to another episode of Hot Takes with me, the Silver Fox, and a little glimmer of hope. We're going to hearken here to a story I've covered before, about a week ago, and it involves Sean Hogg, a man who did terrible things to a young girl, and then who walked free from court because the court said that he was under 25 and therefore lacked the necessary ability to understand the full implications of what he had done. This isn't that the court necessarily wanted to release him, but this was the sentencing guidelines laid down by the SNP government under the then Justice Minister, Mr. Humza Yousaf. And so Humza Yousaf, had, laid this law down that enabled a man in his early 20s to walk free after committing the R of a child. Well done, Humza Yousaf. Anyway, this is a follow-up because there's now been an appeal on that sentence. They're going to drag this man back to court and hopefully, we don't know yet, but hopefully give him a more appropriate sentence, which would be, in my view, 20 or maybe 30 years. Preferably, I would suggest a sentence of 7 days, followed by a short journey of about 18 inches. But anyway, we'll look at this report, see what's... So, Sean Hogg's sentence appealed after the aura of a child walks free from court. I covered this. This was disgusting. This guy did this to a child. He was 21. And the court said, no, you're not mature enough to understand what you've done. And yet, this was brought in by Humza Yousaf as Justice Minister. And he's saying that people under 25 aren't mature enough to understand when they do these things to a child. And yet the SNP thinks a child at 16 is old enough and mature enough to decide what gender it will be and whether to take medication to change its life permanently at that age. They also say that a child of 16 is old enough to vote. Well, you can't have it both ways. Either they're mature and wise enough to do one thing, or they're not. Which is it? Well, it's clearly that they're not mature enough at 16 to make those decisions. And it's clearly also they are way too mature at 21 to get away with that kind of crap. So the Crown Office will appeal an unduly lenient sentence handed down to Sean Hogg, who was convicted of the R of a child earlier this month. The 21-year-old was convicted in March and on April the 3rd was sentenced to just 270 hours of community service, as well as being put under supervision for 3 years and added to the SO's register. But not permanently. He's only on the register for a couple of years as well. He needs to be on there for the rest of his hopefully short, horrible, meaningless, painful life. Anyone who did that to my child certainly wouldn't be expected to be picking up a pension. That's all I'm saying on that subject. That was met with an immediate backlash, with campaigners questioning why a convicted aura of children was allowed to walk free from court. On Friday, it was announced that the Crown Office had taken the unusual step of appealing the sentence, which it judged unduly lenient. And they also need, at that point, to actually fire the judge. The judge did not have to be that lenient. The judge chose to be that lenient. The judge needs to go. We need people sitting on the bench who will administer the justice of the people, not the woke wankery justice of people sitting in a parliament deciding what is the appropriate sentence for people that they like. I suspect this is still part of that push. Let's make the sentences for this kind of crime lighter and lighter and lighter as they normalise the P. It is absolutely disgusting what is happening, and I'm fairly sure it is absolutely my firm belief that the left is doing this. They're salami slicing this piece by piece by piece, making it easier and easier, making it less punishable, making it eventually the norm. It's part of what they do. We must resist it at every occasion. And sending the message here by taking this guy, who was given 270 hours community service, make him do 20 years. Send the message. Deputy Crown Agent for the Crown Office and Procurator Fiscal Service Kenny Donnelly said the sentence is quite rightly the domain of an independent judiciary. However, the law provides for some limited circumstances in which prosecutors have the right to appeal against these sentences, and the appeal court has set a high test to be satisfied for this to happen. the sentence must be unduly lenient, which means that it must be out with the range of sentences which the sentencing judge, taking account of all relevant factors, could reasonably have imposed. The number one thing that judge should have done was look at the man who's committed this crime. He's 21 years of age. He then looks at the child for whom was the victim. And he must then say, that is a grown man and that is a child. And not go, well, what's the minimum sentence? But gone, I'm going to make the sentence even more extreme because that's a child. And it's as simple as that. And any judge that sits there and fails to do that, who says that the standard sort of, it should be for, for a grown man and a woman, let's say 8 years, well, that's a child. So we'll triple it, minimum, and send the message so that people out there will see what you're getting for doing this crime and will therefore hopefully not do this crime. Unless you do anything else, you're only encouraging it. And I did a video yesterday about these people who do things to children and being given anonymity. And again, it's the normalisation of this kind of thing. It's disgusting. The question of Crown appeal against sentence in this case has been carefully considered, and the decision to place this matter before the appeal court has been communicated to the complainer through her representative. The victim's solicitor, Amar Anwar, said, "This morning we were advised that the Lord Advocate has decided that the Crown should appeal the sentence imposed upon Sean Hogg, convicted of the R of a child, on the grounds that it's unduly lenient. My client is relieved and grateful to the Lord Advocate. It has been nearly a month since Sean Hogg walked free from the High Court, ordered to carry out 270 hours of unpaid work after being convicted of the R of a child. My client still does not understand why Hogg was allowed to get on with his life when he had ruined hers. And she wonders how many girls will think there's no point in reporting the R of a child after seeing her Rist walk free. While the police, prosecution and jury did its job, she feels that in the end she was failed by our justice system. And she certainly was. But thankfully, somebody in that system has taken up the cudgel and will hopefully change it and give this guy a proper sentence. It's got to be a long, severe sentence. You do that to a child, you're lucky you're even going to jail. I'm going to finish there and come up. First of all, what the hell is wrong with these judges that they think that that would be an appropriate sentence? But secondly, what the hell is wrong with Humza Yousaf that he would think bringing that law in was anything other than madness? Does he live in such a place where the R of a child means nothing to him? Well, of course, he does have one thing in his mind, and that is the particular belief system he has. The only thing I can think of that he would think that doing something like that, a grown man doing something like that to a child, would be in any way acceptable. I can't think what else would go through the mind of a man to think otherwise. And it is indication, I think, of where he views children. He doesn't seem to want, as Justice Minister, to protect them. He wants to make them the victims of people. Probably people like him. That's the only explanation why they keep making these crimes less important, less punishable, weaker. Eventually, there'll be no crime at all in something like this. We need to fight it. Thank you very much for listening. If you like what you're seeing here on the channel, please do hit the subscribe button, ring the bell, leave a like, leave a comment, please share the video. And until next time, stay safe, stay well. Dear God, protect your children. And goodbye.